11111. Hey, Castle Law customers and people out there who are interested in immigration law. Today I've got James Bebawy on. James is not with Castle Law, but is a very good friend and colleague of mine. He's with James Bebawy Law. It's somebody who we recommend for immigration law and other matters that we don't handle. I just actually was able to meet James within the last year here, but we've struck up quite a relationship. With the new president, immigration is a hot topic. Some people feel like there's no way to gain access to the United States now because of the flux of the immigration laws. James focuses exclusively on immigration as a big principal part of his real estate practice and really knows this stuff locked down. James, welcome.
Thank you, Gary. Thanks first and foremost for that great introduction. I'm humbled by it and happy to be here today discussing some top level, some high level immigration issues. We're not going to get too in depth today, just by because of the nature of this meeting and the time constraints we do have. But I do want to talk about a few different things that are going on in terms of policy and enforcement in the immigration world. As you mentioned, the political climate right now seems to be a lot of policy discussions going on from the executive branch about immigration and how we move forward as a country in that regard. And I think that some important things need to be pointed out. Although no laws have recently necessarily changed, there is a lot changing by way of enforcement and adjudication of these claims.
James, I really don't know anything about immigration other than what I see on TV. What is USCIS?
That's a great question, Gary. USCIS is United States Citizenship and Immigration Services. They are the branch of the government that basically adjudicates a lot of the asylum claims. A lot of the immigration claims, including asylum claims and family-based immigration petitions and naturalization applications. And they just issued a new policy memorandum that basically empowers their officers to adjudicate claims with a new level of discretion. They get to basically now decide whether they deny a petition or issue a notice of intent to deny, which is commonly referred to as an Endo ID. And usually what used to happen is that USCIS would issue an RFE, which is a request for evidence if an application was incomplete. Now they have a wider discretion, those officers, to basically issue a notice of intent to deny. So as I was stating before, although maybe the law hasn't changed, the way that the law is interpreted and adjudicated has changed based on this wider capability and larger sense of discretion that USCIS officers have. So this is something that's potentially scary to a lot of our clients in that, if a document is missing from an immigration package, we were accustomed to getting an RFE or a request for evidence, to which we could reply and make an application complete. It seems though today, with this new policy, that whole rubric and setup is changing, and that we are going to be issued notice of intent to deny, which is a much scarier and more daunting response from the government, because thereafter our clients can then be placed into removal proceedings, and the deportation process can begin on their behalf, which ultimately is the scariest thing that we deal with in our line of work.
Let me ask you this. Your clients, are they folks that are here in the United States? Are they folks who maybe have family members that are here in the United States, but they're overseas and trying to move here? Are your clients from Asia, Europe, Africa, South America? Doesn't matter. Is there a different process for different parts of the world? This is a compound question, but what would be the reason that someone would need an immigration lawyer to handle all of this versus just like filing the paperwork on their own?
That's a great question as well. So the types of immigration procedures that we do, maybe we can start off there, are generally either family-based immigration, which, for example, if a U.S. citizen marries a non-U.S. citizen, they can initiate paperwork to begin to let the non-U.S. citizen spouse adjust status to become a green card holder and thereafter obtain U.S. citizenship through an N-400 or naturalization application. That's one type of case. Those family-based petitions also extend to brothers applying for siblings or parents for children, and all of those types of familial relationships. That being said, some of our clients are here stateside in the United States, and those applications we do file through USCIS, as we discussed. Sometimes a family member and or spouse is located overseas in a different country, in which case we need to file similar applications, but the final step, the adjustment of status, is achieved through the Department of State through a local embassy or consulate overseas, and that's what we refer to as consular processing. So we do have some, to answer your question, we have some clients here stateside. We've got some clients in other countries. We do family-based cases. We also do asylum claims, which is one of the focuses of our practice. People who fear persecution from their home countries and are fleeing here to the United States to attempt to get some refuge. So that's another type of claim that we handle. We do some employment-based immigration. So kind of a combination of all those things. And then to answer your question about, sort of our demographic reach and where most of our clients come from, we have a great deal of clients that come from the Middle East. That may be by virtue of the fact that our office has some staff and myself that speak Arabic. And so that's sometimes a comforting thing to people who can communicate in their native language. But that's not to say that we haven't had clients from South America, from Europe, from Asia, from Australia. So pretty much our reach is worldwide and global, and we're happy, obviously, to help clients from all over the world. And I think the nature of the immigration work that we do is inherently just global.
And when I'm reading through some of these insights that you've given to us, what strikes me and I guess shouldn't be surprising to people or to myself is, again, my view of immigration is just framed by what I personally hear in the media, because I don't do this. And what it sounds like is, I think of things perhaps by listening to the media as black or white, meaning, there was immigration before, there's not immigration now. And so there's just the absolute barrier to entry or a very aggressive approach to not allowing immigration. What I see from your insight is that there was immigration before, and it was a little more, I don't want to use this term because I'm not trying to make it political, a little more liberal in the lower sense of the word, that the standards were a little bit more relaxed. Just like in golf, you could have a mulligan. If you made a mistake on a filing, you could just take another shot. Now it seems with the current political dynamic that immigration is still allowable from all places in the world. It's simply that they're being much more diligent on processing the applications. And perhaps that's why you need someone who really knows this stuff to make sure your T's are crossed and your I's are dotted. Is that a fair statement?
That analysis is bang on, Gary. That's exactly right. And I think that a lot of people try to go it alone, and maybe in a previous era, it was the system was set up in a way that was more conducive to self-filing. And I do have some clients in the past who have done that successfully, but I can tell you for every client that I have in the past that has successfully self-filed, and by self-filed, I mean, did not use an attorney, I can tell you that there's probably 10 to 15 applicants that I get in my office who need to correct something that was self-filed. So that's not to say that it's impossible to do on your own, but especially as you referenced in an era before where if there was a mistake in an application package, these packages sometimes are upwards of 100 or 200 pages. If there was a mistake there, they would issue an RFE for an out-of-date medical exam. Now there's more leverage for USCIS to just flat out deny that application. And I do want to bring to everyone's attention that there are strict deadlines with some of these applications. So, if you were to apply by a deadline previously and then you would get a receipt for your application and then an RFE was issued, you would still be lodged in with that prior receipt date. Now, if you get a notice of intent to deny or just an outright denial on that application, you need to refile from the beginning, and you may have blown through an important deadline for you to sort of capitalize on your vested rights that you have as an immigration applicant. So that being said, there is a new policy memorandum that USCIS just issued also about NTAs, which is notice to appears, which is sort of the beginning or the initiation of removal proceedings. And it's interesting, you said you didn't want to politicize it, and I totally agree with you, but the new guidelines that are sent down this memo are being promulgated, and this is a quote, for the purpose of enhancing public safety in the interior of the United States. So, as you know, as an attorney and from law school, what they've sort of driven into our heads is that things that are done in the name of national security get a lot more leverage, and I think that this is a technique in some instances that's being used for policy changes to be able to tighten the reins a little bit, and so I think that, as you mentioned, I mean, there's not necessarily laws that are physically and on the books changing. It's more of a policy and an enforcement issue that's changing. That's kind of a scary thing.
So I let me ask you this, because I think a lot of people will want to know. I give you a call and say, hey, I happen to be background in Norwegian. So I'm over in Norway, and I say, hey, James, I'm Norwegian. I want to come to the United States. I want to file paperwork. What's the process? How long does that take from the time that I call you to the time that I'm reciting the Pledge of Allegiance or whatever they do at the naturalization ceremonies?
Yes, before you take your oath. So,
Yes.
So that's a good question, but the answer is not a straightforward one, because it really all depends on the status of the applicant as they enter the United States. So someone who is entering as an asylum applicant will have a very different process than somebody who is entering as somebody who's going to apply for asylum, for example, based on an entry as a B1, B2 visitor, is going to have a very different process than somebody who's going to adjust status to green card holder, or what they call LPR status, lawful permanent resident, if they're adjusting based on a family relationship or based on an H-1B employment visa that can later be converted to an immigrant visa. So, there's two types of visas that are issued. There's non-immigrant visas and immigrant visas. Non-immigrant visas are intended to allow the visa holder to visit the United States, while immigrant visas are intended to allow the visa holder to eventually adjust status and become a green card holder. So it really all depends on qualifications, on education, on goals being here, on whether there's an employer sponsor, on what sort of familial relationships you have with U.S. citizens or lawful permanent residents, on what your status was with and your relationship with your previous country, if there's a reason for you to be filing for asylum. So I can't answer the question in terms of timing, partially because it depends on how you enter the United States, and partially because even if somebody enters under one of these certain statuses, the timelines and processing times change drastically, even on a month-to-month basis.
But would it be fair to say, let me ask you this, and I'm just going to pick an arbitrary date because lawyers never want to commit to anything, so I'm going to commit you to something.
Sure.
We don't know anything about the specific facts, so we can't hold James' feet to the fire on this. But let's say 180 days for whatever particular qualification. The point I'm getting at, I guess, is if we go back to this last slide, what concerns me for my clients, because Castle Law, we service clients from all over the Middle East, the UK, Indonesia, Vietnam, because of all the real estate investors that we service. And your last point on this requiring applicants to refile. So if I file on January 1st and on July 1st we get a determination, that clock starts right back over. And so having somebody who's competent, who makes sure that that application is thorough, that there's every single component in it, that can avoid those pitfalls. And this is what you do every day.
Yes, yes. So to speak to that point, yes, absolutely. We would, I mean, what we do here at our office is based on years of experience and templates and previous cases that we filed in similar jurisdictions. We prepare applications very thoroughly. We often like to provide USCIS with more documentation than they request, so as to potentially avoid a notice of intent to deny and avoid our clients being placed into NTAs and getting notices to appear. And so we walk applicants, whether they're at a beginning phase or whether they're at the green card phase applying for citizenship or whatever the case may be. We walk them through the adjustment of status process, through the naturalization process. We submit the documents at the right times. We are cognizant of all deadlines. And we, even for our naturalization applicants who are becoming U.S. citizens, we provide sample civics tests and sample English language tests, as those are requirements to obtain your citizenship at this time. We even go with our applicants to the adjustment of status interviews and the naturalization interviews, and we sort of see the process through from A to Z. We like our clients we refer to them as our legal partners through life. That's how we refer to our clients, and make sure that, from the moment of entry into the United States all the way through their immigration process and beyond, we sort of appreciate that we are leaned on as sort of a navigating guide and voice through the immigration process.
So look, guys, I don't know if this is sinking in for everybody yet. I mean, we're a nation of immigrants, so at some place, somewhere along the way, we all have people who are overseas. Obviously, we have family, friends, relatives who will marry people from overseas. Sometimes, especially now in our society, there's a lot of people who are fearful. There are people who feel like that it is an impossibility to get citizenship. That's not the case. If you want to get your teeth cleaned, you're not going to go to James. You're not going to come to Gary. If you need your bones set, you're going to go to an orthopedic surgeon. So this is exactly the same. This is a very in-depth technical process. That's why I have James on today. We've got 16 to 18 lawyers here. We're very competent. We do a lot of things. We don't do immigration. I don't try to do immigration. So we're lawyers. Theoretically, after 7 years of education, we know a lot about the law. Yet we won't even do this because it's such a technical and sophisticated field. So if you are considering this, if you have family or friends or people who are wanting to come, I have lots of clients who have clients overseas who are investing here. James knows about this stuff. I would definitely reach out to him. And again, especially now, to get you from point A to point B, how important to you is that? Or do you want to monkey around with things for years and keep redoing and redoing and redoing? James, what else? How do our clients get in touch with you? Is there anything that we missed? Anything you want to talk about?
I just want to thank you for the opportunity to let me speak about my passion today, which is immigration law. If everybody couldn't tell yet, I'm really into this stuff, and I wanted to just provide some insight and thanks for allowing me to share some of my contact information. Everything there is correct. I can also be reached via email at james@bebawylaw.com. Other than that, my phone number is there. My client card is there. Anything that I'm happy to help people answer any questions, set up consultations, advise you of rights that you have as an immigrant or non-immigrant, and hopefully help people get on the path to whatever, achieving whatever their immigration goals are.
James, thanks for coming on. I try to surround my clients with people who can bring a tremendous amount of value. I try to surround my clients with people who are smarter than me. Fortunately for me, that's real easy to find those sorts of people. James, you're one of those guys that I count on, a very good friend, a trusted colleague. So thanks for sharing your knowledge, and I hope people will reach out to you. Make it a great day.
Thanks again, Gary. I appreciate the time.